Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. I want to alert you today to a practice that has gotten a few brokers in trouble in recent months. And that is a practice of speeding too quickly through a review of a purchase agreement prepared by a different broker for your client's review. Most of you are familiar with the boilerplate terms of the forms, as you should be, and you're familiar with the blank spaces and the default language that's associated with the blank spaces. For example, an inspection contingency is 10 days by default if there's not another number of days filled in there. But the problem that some brokers have encountered recently is not paying enough attention to the blank spaces. You will find blank spaces on a variety of forms. For example, Form 34 is nothing but a big blank space. Form 36, the counteroffer addendum, has a big blank space. Form 22D has a small blank space at the bottom of the second page. That's the space that's gotten a few brokers into trouble. The broker on the other side of the transaction will fill in Form 22D. They'll check the other box at the very bottom of page 2. Using their computer to prepare the form, they type in a provision that becomes the other paragraph in Form 22D, and buyer and seller both sign the purchase and sale agreement. The problem is that the reviewing broker, not the broker who prepared the Form 22D, but the broker on the other side of the transaction, moves so quickly through a review of the form, has in their mind the notion that they already know everything on the Form 22D, which is true with respect to the boilerplate language. But because of the need to go quickly, or the sense of urgency, and because of a feeling that I already know what's on Form 22D, skips over that blank provision. And that blank provision has gotten a number of brokers and their clients into trouble because the broker on the other side writes a provision in there that is consequential to the party on the other side of the transaction. For example, seller will pay buyer's closing costs. Seller will replace the roof on the property. Seller will leave the bulldozer at closing. When the typically buyer broker uses that provision to create what can be an enormously substantive term of the agreement, and listing broker and seller don't notice it, it still becomes a term of the contract between the parties. That contract term can be a problem for the seller in this case. And if the seller is surprised by that term, surprised at closing or days before closing, who do you think they're going to turn to with their unhappiness? They're probably not going to blame themselves for not reading the contract carefully enough. Instead, they're probably going to look to the listing broker and question why that provision was not brought to their attention. So, brokers, no matter which side of the transaction you're on, look for the blank spaces. Know the forms well enough that you know where all of the potential blank spaces are. And when you see a form in the transaction that has a blank space embedded in it, make sure that you take special attention to look at that blank space, see if there's anything written in it, and make sure that your client agrees with the terms written into that blank space. The blank spaces have every bit as much potential to create contract terms as the boilerplate language or the blanks that are embedded in the boilerplate language. So pay attention to all of it. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.